Welcome to today's discussion on students and their constitutional rights on school campuses. As educational leaders, we often face complex legal and ethical issues related to student rights, and understanding these principles is essential for creating policies that uphold both legal compliance and student freedoms. Let's dive into this important topic. First, let's examine the historical and legal foundation of student rights in schools. Many believe that students lose their constitutional protections once they enter school property, but that is not the case. The Supreme Court decision in Tinker v. Des Moines confirmed that students retain their First Amendment rights, provided their speech does not cause substantial disruption. Similarly, New York v. TLO set the precedent that students have Fourth Amendment protections against unreasonable searches, though school officials can act on reasoned suspicion rather than probable cause. These landmark causes help define how constitutional rights apply within educational settings. Now, let's explore how different school settings impact these rights. Public schools, as government entities, must adhere strictly to constitutional protections, including free speech and due process. Charter schools, while publicly funded, may have varying policies depending on state law. Private schools, on the other hand, are not bound by the same constitutional obligations, but must follow anti-discrimination laws and state education regulations. Virtual schools introduce additional challenges, particularly with policies governing cyberbullying and academic integrity in remote learning environments. A major ongoing debate centers around students' use of social media and free speech. In the case Mahanoy Area School District vs. BL, the Supreme Court ruled that a student's off-campus social media post was protected under the First Amendment, as it did not create a substantial disruption. However, the ruling also acknowledged that schools retain the authority to regulate speech that involves threats, harassment, or significant interference with school operations. This ruling highlights the continuing legal tension between student expression and school authority. Let's look at both sides of this issue. On one hand, advocates for student free speech argue that students should be allowed to express themselves freely, even outside of school, without fear of punishment. On the other hand, school administrators emphasize the need to regulate harmful or disruptive speech, such as cyberbullying, which can impact the school environment and student safety. Striking a balance between these viewpoints remains a legal and ethical challenge for schools today. As an educational leader, I believe that while students' free speech must be protected, schools must also have the authority to address speech that disrupts learning or poses a threat to students and staff. The key is to develop policies that are transparent, legally sound, and ethically balanced. Schools must work with legal experts, educators, and students to ensure policies respect constitutional freedoms while maintaining a safe and respectful learning environment. That wraps up the discussion of students and the law. Thank you for tuning in. Be sure to stay informed and engaged in these critical conversations affecting our schools. Until next time, bye-bye.